What's up, everybody? What's up? What's up? There's something I'm forgetting to do, but I can't think of it. So, yeah, well, hmm. What's up? What's up? Any questions? Any questions? Let me change the topic here. Let's see. What's up, everybody? Let's mirror that. And then about me. Tonight's combo is not about Admiralty, is about inferior courts in the U.S. Constitution. Mm. What's up, everybody? Constitution. All right. That should be good. Now let's go to the Constitution. We're going to YouTube. We'll always mute that. Let me move that over some. Mm-hmm. Let's get the chat out. Pop out the chat. There we go. Put that back there. And we're cooking hot grease, everybody. What's up? What's up? What's up? Perfect. Perfect. All right. Then we'll pull up the Constitution. What's up, everybody? Now, any questions? Any questions? Let me pull this up. Inferior courts. Mic check. Mic check. What's up, everybody? What's up? What's up, everybody? All right, so we got that one. And we're gonna do Black's Law. What's up, everybody? What's up? What's up? And we're gonna call my boy Francis. That's volume 2. Francis again. So that's what? A maxim. And then this one would be perfect, 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 perfect. Need that there. And we need that there. And we need Black's Law 4th edition. And Black's Law 6th edition. All right, so we got that on this side. When conspiracy to deprive rights occur, do I need to simplify the action to back it up, or do I need, hard evidence? It depends on the issue. Believing that they are conspiring, and what action are you using to enforce this? It all depends on specific issues. All right, let's see here. I'm ready for some more people. Civil conspiracy, deprive constitutional and civil rights. Well, you don't, you can't enforce civil rights constitutionally. There's no such thing as civil rights in America. Civil rights come from another country. And did you give away those rights? That's the real question. Did you waive those rights? Did somebody not follow due process? That would be proof if your rights were conspired to be deprived of. Not as a person denied access to language. I don't know what that means. What state? What state are you from? Vermont. And what does the Vermont Bill of Rights say concerning your issue? What's up, everybody? What states are we from? What states are we from? YouTube. Is anybody on YouTube? There is nobody on YouTube. Okay, so we're not showing this stuff. Keep it up, buddy. These are federal laws that apply to what? Federal laws. Can you define federal law? Not a federal statute, because there are no federal laws in Vermont. Vermont has state laws. Primarily, they have a state constitution and constitutional bill of rights. So is your issue federal or is your issue Vermont? And why are you, and if it is federal, why are you talking to the, these are federal laws that apply to who? To Vermont? Federal laws don't apply in Vermont or to Vermont. If it's over a federal issue, that may be different. My neighbor is jamming. He's playing all the jams tonight. What's up, everybody? What states are we from? What states? What's up? What's up? What's up? He said, "Get my drink." Y'all don't hear him? He's yelling very loud. All right, tonight we're going to talk about inferior courts. Inferior courts. Oh, I have notes. I forgot about federal laws. Pennsylvania's in the house. Let's go. Let's talk about Pennsylvania. Pennsylvania. Ooh, I found this out yesterday. Not yesterday, maybe the day before yesterday. Pennsylvania said, what they say? Oh, not that great. No, no, no. Supreme Court of Pennsylvania said that actual possession of land means a foothold on the land. It means actual entry and actual occupation. What's up, everybody? Let's talk. Let's talk. All right, I guess nobody else is coming on. Make record this. Mm, see the camera? It's a big camera. Oh, actually. What's up, everybody? What's up? What's up? Feel free to share it. If you don't know who I am, don't share it. If you know who I am, feel free to share it. That would just be weird. Just random black guys talking on the internet. And so, what do I care? Let's see here. All right, tonight we're going to talk about inferior courts. Mic check on TikTok. Mic check on TikTok. Mic check on YouTube. People keep complaining on YouTube. I don't know what to do, so sorry. Mic check. Mm. I need more agua before I start talking about the feds, okay? Let me go get a thing of water. All right. What's up? What's up? Good evening. Let's see, because I'm almost on a coffee. Let me go make sure I got plenty of water. All right. Tonight, oh, I got to record. Let me hit record. That's what happens when you got a little desk that goes up and down. There you go. All right. All right. We're gonna talk about. Am I recording? I am recording. What's up, everybody? Said really loud. Tonight we're gonna talk about inferior courts. The best way to do this is to just define the word inferior courts. Always start with the Constitution. That is the backdrop on how we see American law. All right. So it's very important. So we start with the federal Constitution. If you're one of the original 13 states, if you were born in one of the original 13 states, you can start. I would start with um, your original state constitution. They don't talk about it, but that original constitution has never been repealed, has never been altered. It still exists. They just don't. Uh, so you can always use that because those constitutions existed before the federal constitution, and that is really a picture or a culmination of all the 13 states' original constitutions. Not original. Some it depends on your state. So this is random, but this is important. So if you're one of the original 13 states, if you were born in one of the original 13 states, okay, well, those very first constitutions, many of them were just their individual declarations of independence from or from Great Britain. So you they may not be as explanative as you may think. So you may have to go to your second, what they call the revision, the second revision of that state constitution, and that will primarily be, I don't know everybody's state, but it would be primarily the actual constitution. Many of those original constitutions they had to do in an emergency of war. So they said, let's declare independence, put a couple of things in there, and if we make it on the other side of this war, then we'll clean up and make a, in my language, not their language, official constitutions. All right. So it just depends. You have to read your original state constitutions. If you don't know them, um, Yale University, I forgot what it's called. Yale has many of the dang it, what's it called? Yale has all of the original documents. Yale, there's a Articles of Confederation from the 1600s. Articles of Confederation. I cannot spell. Articles of Confederation, 1634, something like that. Yale Avalon. That's the name of the uh, Yale Avalon Project is the name of the website. You'll see many of the original. You'll see all of them. They got stuff from they say from the 400s to the 1300s to the 1400s, 1600s, 1700s, 1800s, 1900s, 90s, and 2000s. Shouldn't they lose their office if they go against the Constitution? Uh, this is difficult to explain, but not everything we think is unconstitutional is unconstitutional. And everything we think should happen, I say this all the time, most of what we complain about concerning the government is our fault. And we also don't understand American history, and we don't know how to respond in light of that history because mostly it's not talked about, but and this is a great way to start the conversation, but we haven't had state government since the Civil War. We have no states. We have no states. We have no state governments. And that's a difficult conversation to have because people don't that people think it's conspiracy and all this stuff. Well, since the Civil War, the feds invaded the state. That is what happened. No ifs, ands, buts about it. So there is no, oh, well, these are my state governments and they represent me and they're doing everything in my interest. And then, oh, every now and then they disobey. No, they don't obey it at any time. That's not their constitution. It's ours. And if we don't uphold it and learn the law, well, then nothing gets done. So we can't say, well, why don't they lose their there are we have nobody in office. There are no people occupying state government. They are all extensions of the federal government. And that's a difficult conversation to have, and it's easier for me to just say it like that than to explain the real situation, but that it is true. There are nobody who's working in the Florida or Vermont or Pennsylvania government working for the people. They have not been lawfully elected or appointed by the people. So I hate to say it, but we're on our own. So we gotta learn this law. We gotta learn these constitutions to know what we're supposed to be doing. All right. And that's part of the topic tonight. But I forgot what I was talking about. Oh, you can find your original state constitutions on the Avalon Project by Yale Law School. That's what I was going to say. So let's see here. 1770. Let's just search Constitution. Let's see what we got here. Constitution. 1774. Okay, none of this is. Yeah, here we go. Here we go. Oh, yeah, perfect. So I got Delaware Constitution was on September 21st, 1776. The Constitution of Georgia was on 1777. Maryland's was on 1776. November 1776. They would all be 1770. Well, not all of them. Vermont was 1777. Vermont had a couple constitutions. They had one in 1786, 1777. New York was April 20th, 1777. New Jersey was July 2nd, 1776. Where's Pennsylvania? Let's see. Okay, so yeah, Pennsylvania has a Declaration of Rights. That was September 28th, 1776. There you go. And then they got the plan and frame of government. Let's see. What did New York have? I know Virginia had the first. Well, they say they had the first Declaration of Rights. They say everybody would have got their Bill of Rights from there. June 29th, 1776. So yeah, they did it before July 4th. That's Pennsylvania. New York was in 1777. The resource or has been changed or renamed or removed. So they don't have Virginia's right now. I'm sure you can Google it. Delaware. Delaware was first to declare independence, but they may not have been first to get their constitution. But yeah, you can read your state. Your if you're from one of the original 13 states, you can read your state's constitutions. South Carolina, and then you also have to check that second and third revision of those constitutions. So you have to see it as one long document. So yeah, you like some of y'all states, they probably got like I bet New York's probably got 15 revisions. Okay, well, as far as the Bill of Rights, all of it applies. They can't take it away. Otherwise, they have to call it something other than New York. And you won't find a piece of paper that says, okay, well, we did away with, they can't do away with it. Not without changing the name of the state or country. All right, but we're talking about inferior courts. So, inferior courts. What does the United States Constitution say? Let's see here. Article 1, Section 8 says that Congress shall have power to constitute tribunals inferior to the Supreme Court. Now, this is another topic for another day, and maybe I might look it up later, but they don't call them courts. They said they have the power to constitute tribunals. They don't constitute courts. That makes sense? So this is Article 1, Section 8. The Constitution said, the federal Constitution says that Congress shall have power to constitute tribunals inferior to the Supreme Court, right? Then what is this? Article 2 says that Congress may by law vest the appointment of such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of departments. Okay. And then you got Article 3, which is the judiciary, where they confirm what was written in Article 1 when they say that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may from time to time ordain and establish. And then they say there are judges of both the supreme and inferior courts. All right. All right. So let's go to the definition of inferior courts or the definition. There's always more than one. All right. Now, this is in the early 1800s. They say the definition of an inferior court is YouTube, how do I sound? Am I sounding in and out? Uh, the inferior courts by this term are understood all courts except for the Supreme Court. I don't know if I did a good job explaining this. The reason we're going over the federal constitution is so you know what to look for in your state constitution. But if you're one of the original 13 states, you could have learned this. This is as an example of how they framed the federal constitution. All right. So the definition of an inferior court or inferior courts are all courts except for Supreme Court. That's a pretty easy definition, right? Nothing crazy about that definition. So every court outside of the Supreme Court of your state is an inferior court. The same way they said in the federal constitution that an inferior court would be constituted, ordained, and established by the legislator in Article 1 of the federal constitution is the same way they set it up in your state, all right? You have a state Supreme Court, and then every other state or every other court in your state would be an inferior court. Does that make sense? So no matter what they call it, if it's not the Supreme Court, it is an inferior court, right? Even if they call it a superior court, okay, a superior court is an inferior court. Does that make sense? So, no matter what they call it, if it's not the Supreme there's only one Supreme Court in your state. Actually, California is different, and maybe other states. I don't know this for certain for any other state, but California has they have one Supreme Court, but sometimes they say, "Where's the capital of California?" It's Sacramento. Okay, well, they have a Supreme Court. Their Supreme Court building is in San Francisco, which I guess is close to them or whatever. And then they say sometimes they have Supreme Court sessions in Los Angeles. So I guess they have another building in in South California where they have Supreme Court sessions. I thought that was interesting. So I say you only have one Supreme Court. Well, technically, depending on it would still be one Supreme Court, it's the same justices, but, they would be, California, they sometimes hold sessions in Los Angeles. Alright, but the definition of an inferior court, one of the definitions, the main definition is anything except for the Supreme Court. So any court, you name it, it is an inferior court. Alright? Now, let me go over some other things that are mentioned in the dictionary in relation to inferior courts. All right, let's see here. Not important. Not important. I will get to that. I don't have a pen. I don't have a pen. Appeals, 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 uh, I do have notes. All right, so you got inferior courts primarily appeal in them. See appeal again. Got that. All right, I'll go over these things. This is cool. All right, let me go over some other dictionaries. All right, this is Black's Law First Dictionary, and I have to go all the way through. All right, what is an inferior court? They say this term, inferior court, may denote any court subordinate to the chief appellate tribunal in a particular judicial system, but it is commonly used as the designation of a court of special, limited, and statutory jurisdiction. Those three words are very important, and I'll get into that in a second here, but a court of special, limited, and statutory jurisdiction. That is what an inferior court is, right? So the first thing they told you is that everything outside of a Supreme Court is an inferior court. But the next thing they tell you is that it is a court of special, limited, and statutory jurisdiction. All right. So they say every court outside of the Supreme Court of your state is of special, limited, and statutory jurisdiction. Created by who? Created by the legislator. So you have to see it like this. Technically, the Constitution only creates one court. and that is the Supreme Court. Your state constitution only created one court, and that is the Supreme Court. Every other court outside of that was created from a subordinate called the legislator or the legislative branch. Does that make sense? So every other court outside of the Supreme Court is a inferior court. An inferior court is of special, limited, or statutory jurisdiction. So, and we'll go over that in a second. All right, let's see what else they say. They said because these courts are of special, limited, and statutory jurisdiction, these inferior courts must show the existence and attaching of jurisdiction in any given case in order to give presumptive validity to its judgment. So it has to show, like the Maryland Supreme Court. The Maryland Supreme Court would be created, excuse me, by the Maryland Constitution. But if you went to, I don't know what's in Maryland, a divorce court in Maryland, okay, well, that divorce court was created by the Maryland legislator. It was not created by the Constitution. So if I ask you, uh, these courts were not created by the law of the land. The law of Maryland is the Maryland Constitution. Sense? So any other court outside of the Supreme Court of Maryland, or what they say, because this is a fun fact, Maryland didn't always call it the Maryland Supreme Court. They just called it the Court of Appeals of Maryland, but that was the highest. They say this term inferior court uh, denotes any court subordinate to the chief appellate tribunal. Okay, so Maryland Court of Appeals up until like 2013 or whenever it changed was the highest appellate tribunal. But they didn't call it the Supreme Court, but that's what a Supreme Court is. It is the chief appellate tribunal, right? So, what is an inferior court? Every other court outside of your Supreme Court, out of your state Supreme Court or the federal. Every inferior court is created by special, limited, or statutory jurisdiction. Special, limited, or statutory jurisdiction. And these inferior courts must show the existence and the attaching of jurisdiction in any given case in order to give presumptive validity. So they have to prove the existence of their jurisdiction. That makes sense? Are you saying the Maryland Court of Appeals or go directly to the Supreme Court? The Maryland Supreme Court was not always called the Maryland Supreme Court. It was called the Maryland Court of Appeals or the Court of Appeals for Maryland. They just changed the name. So they don't always have to call it a Supreme Court. It today it's called the Maryland Supreme Court. So that's the highest court. Any other court outside of the Supreme Court of Maryland is an inferior court. Any federal court outside of the Supreme Court of the United States is an inferior court. So there's only 2 types of courts in our country, in your state and on the federal level. There is a Supreme Court, and the other one is inferior. Every other one is inferior to the Supreme Court. The Constitution of Maryland, for example, created the Maryland Supreme Court. Right, so you get this about Tennessee. Okay, well, the Tennessee Constitution created a Tennessee Supreme Court. A constitution creates government. That's what happens. Oh, my neighbors are arguing. Uh, but every other court outside of what the Constitution created was promulgated by the legislator, which is a creation of the Constitution, okay? And they say every inferior court, which is every court outside of the Supreme Court, is a special, limited, and statutory jurisdiction whose record must show the existence and attaching of jurisdiction in any given case in order to show its presumptive validity. All right. They say in England, the courts of judicature are classed generally under two heads: superior courts, inferior courts. They say in England, ancient England, they would have had a Westminster court, and then every other court after that be an inferior court. So we're not from England. All right. All right. They say this. This is. I'm just going over different definitions before I go into what the Supreme Courts have said about inferior jurisdiction. And this is all. I'm not making this stuff up. This is all in the federal Constitution. But every word or every phrase in the federal Constitution has a meaning. You have to interpret those words or those phrases by reference to the common law of England. Why? Because that is the law of the country. All right. Let's see. Here. Cool, cool, cool. Cool, cool, cool. Cool. None of this is important. The Georgia Constitution was formed in 1845. We just was on the website. Go to Avalon, Yale, Avalon. The original Constitution was in 1777. Go. Yeah, you go to the 1700s or the 18th century, search the phrase Constitution, uh, and you will see the Georgia Constitution. Georgia Constitution. Yep. Georgia Constitution was on February 7th, 1777. Now, I said this earlier, you may have came in the live later. Uh, a lot of these original state constitutions from the original 13 states, um, their first constitutions were just their Declaration of Independence. So, like I'm reading the Georgia one, it says, whereas the independence of the United States has so declared on the fourth day of the law, yada, yada, yada. All right, well, they're talking about all this stuff. The reasons they had to set up their original constitutions when they did was as an emergency situation, right? They were in war. So many times you have to go, depending on your state, if you're one of the original 13 states, you have to go to maybe the second revision or the third revision of your state constitution. But all of them are valid. That's what I'm saying. They've never repealed the original state constitutions from the original 13 states. So we really somebody asked me one time on Patreon, well, which one do I read? Read all of them. You go over all wherever they start the Bill of Rights. That's where you will find the legal boundaries of your state. When you start looking for land patents, you'll see that stuff has not been ceded to the federal government at all. It's never been ceded to them. Ceded, CEDED. All right. So inferior courts. Let's see. We're just going over dictionaries here. There we go. Do I do land patents? No. I got a lot of books on them if you wanna read. You wanna get to reading? A lot of books on 'em. Superior courts. They said in American law, superior courts are also inferior courts. Just because they call it superior court, if it's not the Supreme Court, it is an inferior court. Let's go to the next dictionary. Most of learning about land patents is learning the history of your state, learning the history. If you are one of the original 13 states, well, you need to learn all of those kings of England that preceded when your state, when it was a colony started. Here we go. Here we go. The inferior courts. No, that's not it. All right. What is an inferior court? An inferior court is a court of special and limited jurisdiction. They say it must appear on the face of its proceedings that it has jurisdiction and the parties were subjected to its jurisdiction by proper process, or its proceedings will be void. See, if you make it to the Supreme Court, then you don't have to ask where this court came from or who created it. We know who created the California Supreme Court. The California Constitution did. So you don't have to ask to prove its jurisdiction. It was created by the Constitution. But these other courts, which are inferior, you have to challenge their jurisdiction. I'm getting ahead of myself, but that is how you're supposed to do it. Another distance between superior and all right, that's not important. Let's see. Bet. All right, judgment and error. All right, cool. That's a good definition. All right. All right, let's go to another one. What is an inferior court? All right, this one says that this is who is this? This is another Black's Law Dictionary. Says an inferior court is a court whose judgments or decrees can be reviewed. You can't review the Supreme Court. All right. Uh, an inferior court is a court whose judgments or decrees can be reviewed on appeal or writ of error or by a higher tribunal, whether that tribunal be circuit or Supreme Court. And they're citing the Supreme Court of Alabama. They say, what is this definition? This just is just under the definition of courts. So they say there are superior and inferior courts. They said there's a higher appellate system. What I'm really explaining to you guys, and maybe I'm doing a horrible job of explaining it yet, these are all commercial courts. This is what I'm explaining to you. So if you were here yesterday, we talked about admiralty courts. If you were here the day before that, we talked about commerce and where it comes from and what it does and all of these things, right? All right. Well, these inferior courts are established by the legislator. Again, I'm getting ahead of myself because people want the answer to a thing without us understanding a thing, right? So people say, well, what happens when they don't prove jurisdiction? We jurisdiction is a whole nother topic. And I always get in trouble when I explain, well, we gave them jurisdiction by participating in receiving what they offered. All right. But that's another topic for another day. So, um, but this is just understanding what we're dealing with, and they are inferior courts. Uh, and I just explained that one. So that was the one that they're not loading my stuff fast enough. So because my dictionaries are not loading fast enough, so we have to understand, okay, the Constitution says there are these are okay, let me say it right. The Constitution, state or federal, creates a corporation. Do we understand that? Everybody tells me all the time, "Well, the United States is a corporation." And whatever the United States Code citation is 12 USC, yada, yada, yada. All right. Yep. Okay. We believe you. Nobody's doubting you here. Okay. Well, in every part of history on the planet, interacting with a corporation is voluntary. Okay. The Constitution creates a government by way of corporation. There's a United States Supreme Court that says that. There's a United States Supreme Court case that says that. That to them, all governments are corporations. I think I explained this yesterday or the day before when going over commerce. No, I was talking about yesterday a Republican form of government. So the United States Constitution says they're supposed to guarantee to every state in the union a Republican form of government. And we went over what a Republican form of government was. It was actually at the end of the live, so a lot of people weren't there. But they said that a Republican form of government is a government in which the sovereignty is vested in the people. Okay, well, where'd they get that term Republican form of government from? Remember, the Constitution has to be our Constitution, state or federal, has to be understood and explained by reference to the common law of England. That is the law these people who set up this government and this country wanted. All right? So we don't understand anything in this Constitution if it does not come from the common law of England. All right? So when they say a Republican form of government, we have to go to the history of England. When these people were colonists and they were getting ready to break off from England or from Great Britain, which is the name of a corporation, they had to research what a Republican government was. And they went to the first 10 books of the Bible to understand what a Republican form of government was. Why? Because in the first 10 books of the Bible, from Genesis to First Samuel, first or second Samuel, I don't remember. Uh, they had no king. The people of God had no king. They had no secular government over them. They had a large family. They were a large family, and they primarily listened and obeyed to the voice of God. When they set up these states, and then ultimately this federal corporation that comes up in later, okay, they're still supposed to guarantee to every state in the union a Republican form of government where the sovereignty is based on the first 10 books of the Bible. They say it, you look at these early documents. I got books on it on the Patreon. They say they studied Moses and the people of God that were under them. They studied Joshua and the people of God that were under them, and they studied the judges and the people of God that were under them. Not they didn't rewrite the Bible. You can't rewrite the Bible. They went to the Bible to understand what a republican form of government was. They're talking about a specific clause in the Constitution. You cannot understand the Constitution without going to England. And if you don't believe me, read the Declaration of Independence. They fought the largest navy in the world because somebody was taking away English laws from them. Well, you don't know the significance of that if you don't study English laws. Because what is the common law of England? The common law of England is the immemorial practice of the people of ancient England. Okay, well, there's time periods in this. We're not just making up random stuff. You have to study English law before the birth of Christ, 'cause people don't even know England was around before the birth of Christ, right? You have to study before the birth of Christ all the way until a certain point in history, which would have been 1066 when William the Conqueror came in and invaded England and took it over. Okay, well, you learn about these people called the Anglos and the Saxons. Well, the Anglos and the Saxons say they can trace their lineage back to the people of Moses. And when we review their laws, they say they can trace their principles all the way back to the Bible, the first 10 books or the first 5 books, primarily the first 5 books for the law, and then to study the people, you would get that from the first 10 books, right? So when they get to 1776 and they set up these things, okay, well, what is the purpose of the federal constitution? Because the states already people tell me all the time, "Well, there's 2 constitutions." There's not. There was 13 in July 4, 1776. They didn't have a federal constitution for 13 years. Well, they were being a republican form of government, where the sovereignty was based on the people. That's why we got things like a grand jury and a trial by jury and an injured party. We don't just say those things randomly because we think, "Oh, that comes from" you can trace those principles all the way back. Where they get a grand jury from? They got it from the book of Judges, where the elders of the family would be the ones that create the cases. Where they get a trial by jury from? They say it goes all the way back to a dude named Joseph or Jacob. Jacob changed his name to Israel. Israel had 12 sons, and he taught them the law and the facts. And then you get to the New Testament, they say they got it from the 12 patriarchs as well, the 12 apostles, where Jesus said the 12 would judge the nations. Okay, well, they're just mirroring their ancient principles, but none of those are inferior courts. What is an inferior court? An inferior court is created by the legislator, and you don't get attached to that without your consent. And I talk about consent all the time, and that's when people get mad at me and say, "Oh, well, the government treated me so badly, they're taking away my rights." No, we gave them up because we didn't know the law. Let me read it again. They said all inferior courts are ones that are under the Supreme Court. So anytime you have to go through an appellate system, remember, I say this all the time, who are the real judges? Not the guy in the black robe. The real judges are the people, the jury. So if you didn't go to them for whatever issue, well, guess who you're dealing with? Because there's only 2 types of courts to this corporation. You went to a commercial court. You went to a corporation court. Instead of going to the people who are the lawful judges of your states, you went to a magistrate who is not legally, whatever that means, or lawfully or constitutionally a judge. He's only a judge over civil matters, even if they call it criminal. It's ultimately a civil matter. They say you can't even engage with these people unless you've accepted a fiction. They say these people wouldn't even know you were around if you didn't accept fictions from them. But when we me too, I'm not a judge, I'm not a false judge. When we participate and don't know the law and engage in things and lose the ancient principles, and then we wonder why we're subjected and wonder why the government's just so evil and bad and getting away with everything, and then we keep going to them like they're the ones that are gonna fix the problem, we'll never get it fixed. We aren't gonna get it fixed. See, they're not talking about our courts. They're not talking to us. The Constitution is for them. They said we have a law. I prove it in all the states all the time. They say the law of Maryland, the law of Georgia, the law of Texas, the law of California, the law of Washington is the common law of England. People talk about constitutional right. There's no such thing as constitutional rights to the people. There's only constitutional rights to a corporation because a constitution is a commercial document. People say it all the time, and they're right. They want you to keep going to them for all your issues. So I'm talking about the federal constitution, I'm talking about federal things so that we understand there's an actual difference. So they say judicial power of the United States should be in one Supreme Court. What's that? That's a commercial court. If you have to fill out papers in order to deal with them, okay, well, guess what? That's a commercial court. Commercial works on fake paperwork. That's what they do, baby. And guess what an inferior court does? Well, that's the explicitly all paper. That's why all these scammers on the internet keep talking about equity and yeah, that's because they're slaves and they love it. And they want to deceive you into thinking that's the only way you can get things done. Because you start talking about this common law of England, they don't ever talk about the common law of England. I mean, I heard people say they get held in contempt every time. They say, "Brother, I read the common law of England." They say, "Oh, we don't do that no more." Why? Because that's not their law. That's not their law. They have a law, and it's called commerce. It's called the law merchant. But we have a law, and it's called the common law of England. And that common law, the people are the judges of the law and of the fact. And if you didn't go to them for the issue, and if your community where that jury was summoned is not competent and know the law, and if you couldn't explain the law to the judges, the jury, okay, well, guess whose fault it is? You can't say, "Oh, the corrupt government." No, 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 no. We got to say, we got to look in the mirror and say, "Oh man," because if you got to fill out paperwork to get it done and have to go through an appellate system, I'm gonna go over all this in a second, and have to go through an appellate system. Okay, well, that's not the law, not our law, right? So inferior courts. Do we use the U.S. code? The United States code is not law. I just told you what the law was. What is the law of Maryland? The common law of England. See, why are we in these people's court? How did you end up in there? I ask it all the time. How did they know who you were? Who told them you were supposed to be in court? How'd they know to put you in handcuffs? How'd they know to tow your car? It's not magic. They don't have superpowers. So somebody had to give them information. Because they say if you don't know them, they can't do nothing. If you're not on the computer, all right? This is so fun. It's not. Right, right. Somebody said on YouTube, "'Cause we signed papers giving our information." There we go. What does the Fifth Amendment say? People say, "Oh, it's all the Bill of Rights." Okay, you don't wanna talk about the Bill of Rights with me. The Bill of Rights, the Fifth Amendment says you have the right not to be compelled to be a witness against yourself. You have the right to remain silent. The Supreme Court said that comes from the Bible, the right to okay, well, that means any paperwork that you fill out, and it's not their fault, you did it. See, there we go, blaming the government. "Oh, it's their fault, it was their fault." No, it was your ignorance. It was my ignorance because we stood in line at the DMV without reading any constitution. We didn't read no constitution, man, get out my face. We didn't read it, we didn't question, we just did exactly what we were told, and then our parents did exactly what they were told, and then our grandparents did exactly what they were told. Yep, so you're acknowledging that we have a master. That's what they said in the Bible. They said the first 10 books, they didn't have a government, and then because they didn't want to obey the voice of God, didn't wanna obey natural law, okay, well, they complained that they wanted a king to judge them like all the nations. They literally said it's in 1 Samuel 17:12 or 12:17. And they said God gave them a secular government as a judgment. Let me see. Yeah. 1 Samuel 12:17. He said, "Your wickedness is great in asking for a king for yourselves." He said, "You didn't need a king, but you wanted to flirt with the merchants, the Canaanites, the Phoenicians. You wanted commerce. You wanted Baal worship. Okay, well, we now look at where we're under, complaining about how wicked the government is. Yeah, we asked for it. What you talking about? We didn't question nothing. We said, "Oh, you want us to sign right here? Yeah, great. Yeah, yeah, yeah. You want a social security number? You want us to take a driving test? You want us to take a computer test? You want us to okay, oh, well, now they're taking away our rights. They're not obeying the Constitution." And oh, yeah, of course. They said every king after that, every king from Saul was the first king of Israel. Okay, that dude was horrible. Okay, what happened to King David? He started out real good, real great story, and then he ended horribly. What happened to Solomon? Yeah, it got real horrible. Dude had 600 wives, something odd concubines, had issues with all these contracts with all these foreign countries. Mhm. Yeah. They said, "This is what you wanted. What are you complaining about? This is what we get, what exactly what we deserve." When the country started, I think it was Benjamin Franklin, he walked out of some building after some issue or whatever, and they said, "Well, what have you given us?" He said, "A Republican form of government if you can keep it." Yeah, guess what? We ain't kept it. He said it, go Google it. I think it was Benjamin Franklin said, "A Republican government if you can keep it." Guess what? We ain't kept it. Right? So inferior courts. I like this definition real good. Let me go back. I say it all the time. If you're learning this stuff from me, we're all in trouble. You're not supposed to be learning this from me. If the ball was passed down so many times that it ended in my hands, we're in trouble, boys. If you got to learn the Constitution and the common law of England from me, we're doomed, bro. This is it. It's game over. You're like, how did I get this? I didn't want this. I was living a great life. In ignorance. I was like, yay, yay, yay. I'll pay everything. What you need? Yeah, I can afford it. I ain't had no driver's license issues. I wasn't in court every day. So you learning the Constitution from me? Well, we all in trouble. I'm not it. All right. They said again, an inferior court is any court subordinate to the chief appellate tribunal, and yada, 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 in any particular judicial system. They said an inferior court is a court of special, limited, statutory jurisdiction whose record must show the existence and attaching of jurisdiction in any given case in order to give presumptive validity to its judgment. Let me go. They actually have their own definition. Let me go. They shooting it up outside my apartment, boy. All right. An inferior court may denote any court subordinate to the chief appellate tribunal in a particular judicial system, but it is commonly used as the designation of a court of special, limited, and statutory jurisdiction whose record must show the existence and attaching of jurisdiction in any given case. All right, that's a good definition. I like that. Jurisdiction by trickery, resident, citizen, elector, all coerced, yada yada, adhesion contract. The question is, do you have a driver's license or a state ID, or and are you driving cars that they have information on? It's all up to you. You can complain that they did all this evil, and then I can ask you, are you on their computer or are you not on their computer? Be it. You can say, oh, they did all this horrible, wicked things to me. But if you got a state ID in your back pocket right now, I don't want to hear nothing you got to say because it's all voluntary. It's all voluntary. You can keep complaining that all the government's so wicked, or you can go live in the woods. Get some actual real skills, go live in the woods. Oh, there's no way to be free. We're all slaves. No, speak for yourself. I'm getting up out of here. Somebody said, why you keep teaching it? I need about 200 of y'all, and then I'm out of here. I don't care nothing about this stuff. Uh, inferior court. Inferior court. I already read that. Go to the last one. He said, where I'm going? Into the woods. All right, where are we at? Oh, no, did I miss it? Did I miss it? Inferior courts. No, 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 that ain't it. That ain't it. That ain't it. There we go. This term, this is the same. This is another dictionary, but the same thing. I on YouTube video that I read all the definitions. Uh, this term may denote any court subordinate to the chief appellate tribunal in a particular judicial system, but it is also commonly used as the designation of a court of special, limited, or statutory jurisdiction whose record must show the existence and attaching of jurisdiction in any given case in order to give presumptive validity in any case, in order to give to its judgment. All right. All right. Cool, cool, cool. All right. Let's go to the Supreme Court of Alabama because they teach us the best on what an inferior court is. Actually, let me see where I want to end this. All right. All right. This is the Supreme Court of Alabama. The Supreme Court of Alabama said that all courts which an appeal or writ of error lies are inferior courts. So this is the paperwork system. This is what I'm trying to tell you. There is a difference between common law courts. What are common law courts? What is the real Supreme Court? Because they call it a Supreme Court, but all it is an appellate system. And you study the Supreme Court, well, they don't have no law power. All they have are the power to give opinions, explanations, and findings. They say, "This is what we found," or "These are our opinions," or, uh, I forgot the third thing I just said. So, they have findings and opinions, and they only write writs of errors to lower courts. That's their only job. They're an appellate system. Their job is somebody uses the commercial system to go all the way up to the top, and then the Supreme Court has to answer on whether the issue that was brought before them was constitutional. And that can take years. People don't know that. People don't know stuff don't ever make it to the Supreme Court. There's so many cases, there's so many issues that never make it to the Supreme Court. And what's happened over the years is they're flooding the system so that things don't make it to the Supreme Court. So they create a case on anything. And then you appeal because we don't know the common law, so we think the only way to get things solved is by going to the commercial system, because they don't tell us this, and it's not in a world of ignorance, it's now not as great, but a trial by jury makes a decision on something, it's final. No appellate system for the trial by jury. Why? Because what the actual judges say is the law in a particular case, which is good if that jury is competent and knows a little bit about the law and about rights and was raised in a world where the 10 commandments have some weight. But in the world of ignorance, if what they say is the law in your case and you can't teach them otherwise, it's not in a world of ignorance, which we live in today, right? So people don't know the trial by jury is the final say so. I said this yesterday. I said, at the time of the Revolutionary War, I read it. They were talking about admiralty issues, leading up to the Revolutionary War. Okay, well, they said the governor's courts, which were maritime military courts, would not convict, or they said didn't have jurisdiction, and the common law court would not convict. What would happen? Somebody would have revenue issues, and because the governor's courts, what are those? Inferior courts created by commercialism, didn't have jurisdiction. When they would bring it before the jury would throw it out, or they would bring it to the grand jury, and the grand jury would never approve of it. Why? Because they understood rights were being taken away, and when they threw a case out, or if the trial by jury, what they call a petite jury, would say not guilty or whatever, or nullify or whatever, okay, well, that was the law. You couldn't try the case again. That was it. I'm teaching you one side of it, just so people understand what the Constitution's about. So, people say all the time, "Well, I learned equity and I filled out all this paperwork and I submitted it to them." Yeah, but it's still up to the subjection of guys in black robes. They don't have to do anything you tell them. People tell me all the time, "Oh, judge, no, they delay my stuff. I sat in jail for months and weeks and da, 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 all type of corruption." Right? Okay, that's what happens when you go to a corrupt system. Instead of investing in a community, which I'm not saying this stuff is easy. I'm not saying we can just do this tomorrow. I'm saying this is why this stuff is important, because you get one good county where you've given them basic information on how the law is actually supposed to work, and you bring this issue before a competent jury. Okay, well, they're not gonna allow if they know there's no such thing as a crime where there's no injured party, okay, well, they're not gonna prosecute anything or convict anything or find somebody guilty of something where there was no injured party. Or if you got a grand jury who controls everything, doesn't let any fake cases get through, and they say, "Nope, we're not prosecuting it, we're not hearing it." Okay, well, that guess where the real power lies? Not in inferior and Supreme Court. I say it all the time. What is the real Supreme Court? The real Supreme Court is an actual injured party, a grand jury, and a trial by jury. That is the real Supreme Court, and they don't ever have to call it a Supreme Court. What that trial by jury says is the law, because why? The Supreme Court or the Constitution of Illinois and the Constitution of Indiana says that the jury are the judges of the law and the facts, not the guys in the black robe. And what if you are the injured party? You can request a jury. No, you don't sue. You request a trial by jury. You gotta read our state constitutions. All this stuff is in there. We just don't read it. We don't talk about the Federal Bill of Rights and federal law. No, that's not the law. The law is the common law of England. Suing is commercialism. They didn't call them lawsuits if you had a real injured party. Because what happens when you have a corrupt government? Well, guess who is supposed to be dealing with corrupt government officials? The grand jury. That is literally their job. And we don't control no grand juries in this country. Go study grand jury. Let me read a grand jury to you. They said what the FBI is today is what the grand jury was in England. And that's the people. Let me go to common law. Grand jury. That's not important. Boom, here we go. They said an attorney has no right to give an opinion to the grand jury unless his opinion is requested. They ain't never told a grand jury that. Not in our lifetime. They said the attorney see, we don't know how the commercial world works. Well, today, an attorney is gatekeeping. We're supposed to be able to go to the grand jury for anything without an attorney, but they put an attorney to gatekeep the grand jury system from us, right? So they said an attorney has no right to give an opinion to the grand jury unless his opinion is requested by the grand jury. All right, what else? Here we go. They said the grand jury is an institution. This is the United States Supreme Court. They said the grand jury is an institution separate from the courts. I said this is not a commercial entity, right? Because y'all gonna tell me, oh, the United States is a corporation. Okay, well, the grand jury is not. It is the institution of the people from the common law of England. They said the grand jury is an institution separate from the courts. The courts do not preside over the grand jury. They said this is rooted in long centuries of Anglo-American history. They said it is a constitutional fixture in its own right. You're not supposed to be suing for right violations. You're supposed to be going to the grand jury for indictments to put people who claim to be of the government who violate the Constitution in prison. All y'all want is fake Federal Reserve notes. That's all y'all want. And we're never gonna get anything done with that. They said the grand jury is separate from the courts. The courts do not preside over the grand jury. They said this is rooted in long centuries of Anglo-American history. It is a constitutional fixture in its own right. They said in fact, the whole theory of the grand jury's function is that it belongs to no branch of institutional government. The grand jury is not a commercial entity. That's what I'm telling y'all. And we're supposed to be going to them instead of writing fake paperwork to an inferior court or appealing up to a Supreme Court. They said we supposed to have a grand jury and we're supposed to have a trial by jury. We're supposed to be going through the people. Unless you're actually participating in commerce by owning a corporation is the only time that you're supposed to be going to inferior and superior courts or inferior and supreme courts because that's dealing with commercial things. They said the whole fact and theory that this function belongs to no branch of the institutional government, serving as a referee between the government and the people. They said the grand jury requires no authorization. How much authorization? None. They said the grand jury requires no authorization to initiate an investigation, nor does the prosecutor require a legal court to seek a grand jury indictment. They said the grand jury generally operates without the interference of a presiding judge. So we could just see, we never had to go to these people ever. You understand how important this is? We never had to go to people in black robes to get the situations we had issued or dealt with. Never had to. But they blinded us with commerce and convenience. And now they got TV shows. They don't make no TV shows about no grand jury or a trial by jury. No, they make it about a guy in a black robe. They got Judge Judy, Judge Joe Brown. Okay, well, those are not judges, right? They got Law and Order where they teach you all. It's all commerce. That's all we know. They said the grand jury generally operates without the interference of a presiding judge, and it swears in its own witnesses and deliberates in total secrecy. They said that you never had to go to the courts, commercial courts, to deal with issues. You understand how important this is? That was a power of grand jury. Let's read this. All right. Who is this? This is the federal Supreme Court. Uh, they said the institution of the grand jury is deeply rooted in Anglo-American history. They said in England, the grand jury served as the body of accusers sworn to discover and present persons suspected of criminal wrongdoing and a protector of citizens against arbitrary and oppressive governmental action. They said in this country, the founders thought the grand jury was so essential to the basic liberties that they provided that serious crimes can only be instituted by a presentment or indictment of a grand jury. They said grand jury's historic functions survive to this day. Its responsibilities include determination on whether there is probable cause and the protection of citizens against unfounded criminal prosecutions. Uh, Here we go. Who is this? This is the federal Supreme Court. They said the Fifth Amendment provides federal prosecution for capital, otherwise uh, crimes must be instituted by presentments or indictments of grand jury. Grand jury is an English institution brought to this country by early colonists and incorporated in the Constitution by the founders. They said the basic purpose of the English grand jury was to provide a fair method for instituting criminal proceedings against persons believed to have committed crimes. Grand jurors were the people, and their work was not hampered by rigid procedural or evidential rules. They say grand jurors could act on their own knowledge and were free to make their presentments or indictments on such information as they deemed satisfactory. In England, they were free from the control of the crown or judges. They said even in England under a monarchy, they were in charge. As long as it was not a valid commercial issue. They were free from the control of the crown of Great Britain or their judges. They said in this country, as in England of old, the grand jury has convened a body of laymen, free from the technical rules, acting in secret, pledged to indict no one because of prejudice and to free no one because of special favor. They said in England, English grand juries were free to act on their own knowledge. What does that mean? That means you go in and say, "Hey, these government employees, these police officers, this whoever is not obeying the law. These are reasons why they're not obeying the law, and they have to pay a price for the violation of a constitutional issue." And they said, "All right, we'll get to it." And if they determine it be valid, okay, well, they send an indictment. See, we're supposed to be controlling this corporation. We don't control nothing. And the grand jury would go get the sheriff and say, "All right, we need you to go pick up X, Y, and Z, and we're gonna grill him. We've reviewed the evidence. All right, well, now we're gonna have a trial by jury." And on both instances, you would answer to the people. Yada, yada. They said yada, yada, yada. They said there's no case that has ever been cited for reversing the judgment of a grand jury. Upon valid evidence. It says that. I didn't say it, but that needs to be there are crooked grand juries today in America too, so I'm not naive to say, "Oh, well, that's a perfect system." No, I know corrupt people are everywhere. They said upon valid evidence. Alright, they said concerning the Fifth Amendment relative to the organization of grand juries, recognize that such a jury as being possessed of the same powers that pertain to its British prototype. They said it is a grand inquest, a body of powers of instant investigation and inquisition, the scope of whose inquiries is not to be limited narrowly by questions of propriety or forecast or of the probable results of the investigation. They said I'm trying to find one. There's one where they say the FBI is it's, uh, they is a prototype of the grand jury. Trying to see where it says, sorry. I'm still talking about inferior courts, by the way, but, this is the other side of this. If you hang out with me till the new year, I'll talk about the common law of England. I just wanna get videos made on the Constitution to see where these things come from. Boom, boom, boom. Here we go. I don't know what case it is, but it says investigative agencies of the executive branch of government are like a grand jury. They said the grand jury is supposed to investigate the investigators. All right. William Blackstone said that the grand jury is sworn to inquire for the body of the county. There's supposed to be a grand jury. Well, I can't say that. But yeah, there's supposed to be a grand jury in every county. And the grand jury is supposed to know all of their powers, and I bet $1,000 they don't know all of their powers in America. They said that William Blackstone said that when the grand jury has heard the evidence, if they think it is a groundless accusation, then they would write on the back of the bill, ignoramus, or we know nothing of it. So whenever they would get a fake case where there was no injured party, they would write ignoramus on the back of it. They said, no, don't let them do that. Get on about our face. They said if they believe the indictment is said to be sound, then the party stands indicted. They called it a good presentment or an ignoramus. So if they had a good presentment, they would create the case. They didn't have a good presentment, ignoramus. They said the grand jury is an institution of English speaking countries. It has played in some of the most stirring events in history of the Anglo Saxon race. Remember, that's before William the Conqueror. That's before the year 1066. All right. I forgot where I was at. What is an inferior court? The Supreme Court of Alabama said that all courts which appeal or writ of pure lies are inferior courts. They may be reviewed, annulled, or affirmed. Any court organized by the legislature may be reviewed by appeal or writ of error. I'm reading this from my Patreon called Constitution Academy. It's $5 a month. It is at the top of my TikTok page. It's the only link on my TikTok page. Uh, so I'm reading everything I just read you about the grand jury. I got from law books or Supreme Court cases. They said any court organized by the legislator. All right, what did we just learn? The grand jury is not organized by the legislature. They said it's not even a part of the court's institutional system. They said court organized by the legislator may be reviewed by appeal, written error, inferior court of the Constitution. All right. This is the Supreme Court of Oregon. They said in regard to of inferior jurisdiction, if the record does not show upon its face the necessary facts or the facts necessary to give jurisdiction, they will be presumed not to have existed. Presumption may be rebutted and the jurisdictional facts established. That's the Supreme Court of Oregon. Now, here we go. Here's the fun stuff. This is the Supreme Court of Alabama. Let me take a little sip. All right, let me. All right, it says it is a settled rule. This is the Supreme Court of Alabama talking about inferior courts. They said it is a settled rule that where a special authority and derogation of the common law, so they say it's separate from the common law, or it does not derive from the common law. So they said where a special authority is in derogation of the law and it is conferred by statute, it becomes an inferior court. Let me read this definition again. They said an inferior court is any court it to the chief appellate tribunal in a particular judicial system. It says it is designated as a court of special, limited, and statutory jurisdiction whose record must show the existence and attaching of jurisdiction in any given case in order to give presumptive validity to its judgment. The Supreme Court of Alabama said it is a settled rule that where a special authority outside of the common law is conferred by statute, it becomes an inferior or limited court. What did they say? They said where this authority is created by statute, it is an inferior or limited court. So how do you know it's an inferior court? If the issue that you're in there over is over a statute and not an issue at common law, okay, well, guess what? You're in a inferior limited court. Let's say it again. This is another case. The Supreme Court of Alabama said where the issue that you're in there over is unknown to the common law and would have no existence except for statutes, it becomes a court of inferior or limited jurisdiction. They said a circuit court is a court of general jurisdiction. But if the issue that you're in there over is over a statute, then it becomes a court of inferior or limited jurisdiction. The Supreme Court of Alabama said in another case that if the issue that you're in there is not in conformity with the course of common law, the rule is we're a court of general jurisdiction. Even if you think it is a solid court, they said where a court of general jurisdiction has a special authority conferred by a statute, it's an inferior court, an inferior or limited court. They said the power to grant divorce, this is another case from the Supreme Court of Alabama, said that the power to grant divorce is not of the general jurisdiction. So you won't find divorce in the Constitution of your state, right? They said the power to grant divorce is not of general jurisdiction. They are of courts of limited and special jurisdiction. Where a special authority was created by a statute becomes inferior or limited court. They say in another case, the jurisdiction of a probate court is a statutory limited jurisdiction. They said the jurisdiction of the circuit court as a court of equity is also statutory and limited. They said the jurisdiction only be given power by a person con they said the law in Alabama is the only way to give circuit court or a probate court uh, the only way to give power to a probate or a divorce court is through a or they say doing this is a statutory and limited jurisdiction, but it is in existence by pursuing the mode prescribed by statute. Sorry, butcher that whole sentence. I got too many P's in there. uh, so they said this can only give creation They say it again in another case. They said the probate court indulge every presumption in favor of its presume that they have it until somebody contests it. Now, again, this is the paperwork side of it. This is why you have to read your state constitutions. I think Ohio and Montana say you get a trial by jury in every civil case in their constitutions, in their state con they said in a civil case you get it, in a criminal case you get it. Of course you get it, but they said in a civil case you get it. He said, "What's the Alabama case on divorce? I need it." Everything that I'm reading you is on my Patreon at the top of my you just go to the Alabama collection, and you will see all the cases pertaining to Alabama, right? So what is an inferior court? If the issue that you're in that is because of a it is an inferior and limited court. They say the power to grant divorce. Okay, well, who created the divorce? Whoever signed a marriage certificate. So you wouldn't be in there. They even if you plan, okay, well, if you would have never signed that marriage certificate, if you would have rightly defined what a marriage certificate is and what it does and who it subjects you to, and you measured against the rights in the Constitution, okay, well, they would never have a power to grant divorce. See, we don't like the other side of this inferior courts because you don't end up in there. Too, I'm not special. We don't end up in these courts unless we have given them some information. They don't know who we are. You know how many people in this country? It's over 340. Okay, well, how do they know who you are? How did they know that they could grant with you? How'd they know they could tow your car or put you in handcuffs on a warrant? All right, so that is an inferior court. If the issue that you're in there over is not based on something in the Constitution, but based on something in a statute, okay, well, you're in an inferior court. And they said the way you fight these inferior courts by contesting the jurisdiction. Really, you're not contesting the jurisdiction, you're contesting the statute. Measuring them against the Bill of Rights, your state Bill of Rights. Or you learn the law and you explain it to a jury. All statutory offenses are heard in inferior courts. Even if you end up in a federal court or whatever. Okay, well, if you're the reason you're in there is based on the statute. They say they have no jurisdiction unless you've consented by a plea, by a all right, what else? The Supreme Court of Ohio says there are that there okay, the Supreme Court of Ohio is, um, citing an ancient law book, an old English law book. So they're citing a book that says they're talking about courts of record. They said there are 3 types of courts of record, and they said there's a supreme, superior, and inferior. They said inferior courts not of uh, ones that can fine and imprison contempt. The others have no such power. But they're citing the book in early 1700s, 1710, and they say the courts are of 2 kinds: courts of record, courts not of record, supreme, superior, and inferior courts. They say inferior courts are all is felon in possession considered inferior? If there was no injured party against you, probably in there for is not in the state constitution. Alright, now the final part of this is for me. Actually, do I have some other stuff? Let's see. Mm, I forgot about that. I'll read that. Let me read that right now. Actually, I forgot. Under the definition, the court has no jurisdiction beyond what is expressly delegated. They said, well, this is another one. They said the Supreme Court said the Supreme Court of California said the legislator may vest some powers of quasi judicial nature in ministerial officers. Okay, those are the magistrates. A judge of an inferior court is not called a judge. They're called a magistrate. Magistrate are ministers of a religious order. But they said there are only, well, I said there are only two types of courts. They said your court has no jurisdiction beyond what is expressly delegated. I actually have the law book they cite. Yeah, they said what year is this? This is the year 17. Well, these are English cases. So whatever cases are from the year 1717 to 1718. This is a British case that says the inferior courts, in inferior courts, everything that makes the gift of the action must be laid within the jurisdiction. Otherwise, this is ancient. It says, otherwise, it is a matter of aggravation. So they say in inferior courts, everything must be laid. You got some decent things in, out, over here. What that means. Does it sound bad on YouTube? Fade. Oh, I think it's the 2 mics. What about now? Maybe the mics are bad. Maybe I probably need a new mic. Yes, what about now? They're pretty separate. I don't know how microphones and water are good either. You can tell I thought I was better at technology than this. But so let me move this over there, and then I don't know if 2 mics are supposed to be in together. I have no clue. it could be the feds, you never know. It might not be me, I may be doing everything right, but I don't know how for you. But I do record. I am recording this on my actual camera, and I'm uploading all of it, on YouTube as clips. So, I really wish I could only live stream on YouTube, but the YouTube is not discoverable, right? You go discover on other platforms, and unless people search for it, YouTube is based on search. So if you don't search for it or you don't know to search for it, push your stuff to anybody. You have to search for it, especially when they censor you. Uh, TikTok, even though they censor me on there too, uh, it is more discoverable. But okay, yeah, that's it. All right, inferior courts. All courts except Supreme Courts are inferior. Circuit courts are inferior. District courts are inferior. An inferior court has no jurisdiction beyond what is expressly delegated. All right, now here are the writs in a um, inferior court system. Because you have remember all of this is appellate. You have to way to the top. That's what I was gonna say. Appeals. You only can appeal a trial by jury. You understand that? You can't nullification. Can't appeal it, and then can't appeal it if you're on the receiving end, right? Um, so I probably shouldn't say this on the internet, but they got a thing. I think it's a case that's this website that to Supreme Court cases. They say the IRS is subject to Supreme Court cases. Okay, well, they're subject to a trial by jury too. Whatever the jury says is the law. Or a state issue. So they don't put that on there though, because that's the thing they fought the Revolutionary War over, right? So tell you important. All right. All right, the writs. If you love your commercial paperwork, this is what you gotta and I'm not finna pull those up. Maybe I'll pull here we go. Mandamus. I have a mandamus right here. What is a mandamus? A mandamus is the name of the writ, principle which the proceedings were in Latin. Mandamus means we command. It is a command issued in the name of the sovereign authority from a superior court having jurisdiction. Remember, a superior court is still superior court. But they said having some jurisdiction and is directed to some corporation or to an inferior court with the jurisdiction of such requiring either the person, the corporation, or the inferior court to do some particular side. Let me see if there's anything. They got a whole thing about a mandamus. So a mandamus is that they call that a common law. But remember, all of this stuff, the timeline, a common law, and I think it was King Henry first or second, the guy after William the Conqueror introduced the writ system. So that's not the ancient, I would call the real require no paperwork. Mandamus is a writ saying we command somebody who is a person or an inferior court to do something, requiring them to do anything therein specified, which pertains to their office or duty. I didn't say that earlier. So that is operative. The mandamus is a command requiring somebody to do something in their office or duty. So that is a writ that goes in appellate inferior court. Alright. Oh, that's the one that I need to Up. They said prohibition is what they used during the Revolutionary War to stop to slow down admiralty courts. Actually, I didn't have to do that. Prohibition. P P O P. There we go. We're close. Probate. Oh, Proctor. Prof. Prohibition. All right. A prohibition is the name of a writ issued by a court to the judge and parties of a suit in an inferior, commanding them to cease from the prosecution of the same upon a suggestion that the cause originally or some collateral matter arising there does not belong to that jurisdiction. So this is they said this is what they did during the Revolutionary War period uh, against admiralty in state will what they say to cease from the prosecution of a right. So a prohibition writ. Somebody type that prohibition writ or a writ prohibition. All right. What's the other one? Quo warranto. These are all what they would call common law writ. They said we're not typing any of that, bro. All right, a quo warranto is a writ of a writ issued in the name of a government, uh, a person or corporation. Excuse me, a person or corporation that usurps any franchise or office. And this writ is commanding the sheriff of the county and the to be and appear before the court whence the writ issued at a time and place therein to show quo warranto or by what authority had to do they all right. They say, and I've never used any of these things, so I don't fight so it's to dismiss the case. Instead of going into they would submit these types of courts and never have to go in there. Because if the magistrate approved of it, they actually showed that they couldn't prove by what authority they were doing these things, okay, well, then the case out. What are the 3 again? So you got a mandamus, so MANDAMUS. They said a prohibition, a prohibition, and then they said they got a warranto, QUO, warrant means authority, warrant means power, warranto, so just add a O at the end of the word warrant. QUO, warrant O. and I'm sure maybe you wanna buy book I got some books on there. I actually have I just uploaded them. I got a book I got 2 books on all writs. I just uploaded them. What I would do is if you get these books, let me see, Colorado Supreme Court, North Carolina, I forgot about that. I got so much stuff on this Patreon, y'all. Y'all better join this thing. All right, let's common law writs and pleadings. Yep, I got 2 books. What I would do is once I get those books, I would Google if the survey you're trying to use is accepted in state courts, and then, whatever you gotta do uh, to submit those documents. Alright, the next one is I actually don't know how to pronounce this. I'm gonna spell it, and then I'm gonna butcher how it sounds. It's called a bill of certiorari or certiorari, certiorari. Now, I wanna be very clear, all of this is equity. Equity. I don't like it at all. Alright? Uh, but just these are things you can submit in commercial courts, alright? They said a bill of certiorari, chancery chancery is equity. All of this is equity. This is not 'cause remember, you're going to a commercial court to get these things done. These things are not lawful based on commercial charter. You got is based on commercial charter. Traffic court, whether it's a divorce, it's a probate court, whether it's revenue based on commercial charters, right? So, you can either learn how to get a trial by jury, learn this fake paperwork. Now I will say federally, you probably wanna learn this stuff. Federally, you're gonna need to learn this stuff. The federal government is a corporation. Their law is not the common law. You just can't explain their constitution, which creates their government without a common law, but they are not a common law institution, okay? So federally, I will say, yes, you do need to learn these things. You need to learn what mandamus is, prohibition is, a full warranto, and a certiorari. I said it right the first time, times. But it says certiorari is praying writ to remove a cause from an inferior court. They're all inferior courts. Alright, so S or CERTIRA. Somebody's got it in the section. And this is a chancery writ. They tell you, I mean, chancery means a religious prayer that you're asking for something an inferior court to be brought to a superior court, and you will keep doing that to the Supreme They can delay it, they can take their sweet time in approving it. So understand all of this is subject to because you have no control over if they approve or disapprove it. Keep feeling that's all. That's all you have in this system is to go to guys in black robes to get these things approved. Real fun, ain't it? People tell me all the time, "Bro, I'm still waiting on yada, yada, yada." Okay, well, I don't know what to tell you. Alright, and the last one is a habeas corpus. Everybody should know this. They say this is the ultimate writ. Habeas Alright, habeas corpus is the common law writ. This is it. You're dealing with corporations that falsely imprison, supposed to be writing in order to get corpus means body. This is technically a medical term. In ancient this is, what they would do to prove that how somebody died, if they followed the proper procedures in determining a cause of death or any of that type of stuff, right? So this is a medical term turned into a criminal matter, right? So somebody falsely in prison, they have to go through the process to make sure that it was lawful in order for them to verify that you were not falsely in were falsely in prison, right? So if you end up in prison or jail, whatever, they say for jail or prison. All right, well, hey, typically after a sentence, this is typically after a judgment from an inferior court. Hey, this is not actually boom, here we go. Here we go. Here we go. Perfect. 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 Oh, they got a big see this they got 3 pages worth of definition for a habeas corpus. A writ of habeas corpus is an order in writing signed by the judge who grants the same and sealed with the seal of the court of which he is a judge, issued in the name of the sovereign where it is granted by such a judge thereof having lawful authority to issue the same. They give you all this fake words before they get to the definition. They said directed to anyone having a person in his custody or under his restraint, commanding him to produce such person at a certain time and place, and to state the reasons why he is held in custody or under restraint. This writ was at common law considered as a remedy to remove an illegal restraint against a free man. Somebody type habeas corpus in the comment section. They said this writ was at common law considered as a remedy to remove an illegal restraint on a free man. And then they go into all they're talking about how this started in ancient England. Some guy named Charles, probably King Charles or something like that. I don't know. Habeas corpus has been substantially incorporated into the jurisprudence of every state in and they got a bunch of stuff on it. Habeas corpus law, Pennsylvania. They got one in New York. They got them in all the states, but that's these. So yeah, those are your writs. Those are the primary writs in your 2 hours. I did it. I always make it to 2 hours. Alright, so what is an inferior court? All courts outside of the Supreme Court is they said a jurisdiction of an inferior court has no jurisdiction beyond what is expressly delegated. So and this is primarily talking about federal in the Constitution. So any federal agency that exists or any court by way of that federal agency or by that department has to expressly explain who they are, why they're doing what they're doing, what their authority is. And then, uh, what do how do inferior courts exist? They exist by way of special authority created by statute. So if you're the reason you're in that court is over a statute, and you know it is inferior court, and it is your job to either get a trial by jury or, contest the really, you're not contesting the jurisdiction. You're supposed to measure that statute against due process, against the common law due process. If there is an injured party, good luck. But if there is, then you have to measure it against the state constitution, Bill of Rights, and you have to be able to trace the Bill of Rights back to the common law of England. Because due process of law says that they're not allowed to take, life property. Is no jurisdiction, or where there is no dang it, see, I read that comment. Without the lawful judgment of your peers or due process of law. They're not supposed to take your life or property except by the lawful judgment of your peers. Challenging jurisdiction, again, you wouldn't be in if they didn't have jurisdiction. So, if you end up in there, then your job is to challenge due process. Their actions, their statutes versus the Bill of Rights, and show how they did not follow due process, right? So let's say, for instance, okay, well, there was no injured party. Okay, you can trace that, the right to face your accuser in your state constitution's Bill of Rights, all the way back to the Magna Carta that says, yeah, Michigan government has the Magna Carta on their website. They say, search the word sheriff. They say, let's see, that no sheriff, constable, coroner, or other bailiffs shall hold police. They're not allowed to accuse people when there is no injured party. An attorney can't be an accuser, an attorney can't be in a witness. If you go to court and you look over there, there's no injured party, and there's just a bunch of bar members, okay, that's not why we're supposed to be in court. There's supposed to be an injured party, because the law of the land is the common law of England, not statute. You have to be able to prove all this. You have to be able to show all this stuff. Yeah, a police officer did not create a valid complaint which would authorize a police officer cannot be an injured party in the official he can't be in uniform talking about he got injured. No, you get paid to get injured. That's what we pay you for. We don't pay them. That's what the foreigners pay you for. That's what the merchants pay you for. They pay you to get shot. Right? You're paid to get hurt. So you have to be able to show that. You have to be able to prove that. Are you on the Patreon? You need to join the Patreon and get to reading. You got over 24 law dictionaries. Go to a website, go to a computer. You may not be able to do it from your phone. You may need to go to the library and sign up. Any questions? Any questions? So that was inferior. Any questions? Any questions? Or some of y'all need to go to your nearest law library and find all the rights inside of those